So, I never like following Burju. She's more beautiful than I am, as you can see. And I have PowerPoint envy. Those were very cool. I have no movies. I have no pictures. They don't go around in circles. So this is going to be very boring for you all. It's filled with like legal text, mumbo jumbo. So my confession is I'm a law professor, and you're going to get a lot of law in this one. I want to try to help unpack the question a little bit that the two speakers were presenting before you, which is essentially, so does NAFTA provide a private party rights to appeal a court implementation of its own utility doctrine to an international investment tribunal, right? So that's what's going on. That's what the first speaker set up for you. So, you know, the Eli Lilly was unhappy. It litigated all the way through the courts of Canada, was unhappy with the interpretation of a utility doctrine that has not been challenged under NAFTA or the WTO by any party. So nobody's arguing that Canada doesn't have a utility doctrine. What they're arguing is that they can challenge, they can appeal from national courts into an international tribunal under what's called investor-state dispute settlement. So, so NAFTA has an intellectual property chapter. It's been quoted by both parties, right? In fact, it's the first free trade agreement in the world to have an intellectual property chapter and an investment-state dispute chapter. So a first key component of NAFTA is that it actually has two dispute settlement apparatus. So there's, I forget how many chapters in NAFTA, probably close to 24 different chapters. Intellectual property is just one of them. And for every chapter except for one, the dispute settlement is supposed to be state to state. There's a dispute settlement chapter that says if a state is unhappy with compliance, it can take another state to arbitration. The investment chapter, just that sole chapter, chapter 11, has a separate dispute mechanism. So under the investment chapter, a private party can bring a state into arbitration. But it's not for the entire agreement. The investment chapter only allows investor-state private adjudication against a party for violations of that chapter, of the investment chapter only. It does not actually give, so when Andrew started out with the claim here as a claim around 1709, well, the investment chapter doesn't give you a claim to adjudicate 1709 under investor-state dispute. You have to have a different theory, and this is the first step for why Lilly's theory is very broad in this case. It has to bootstrap 1709 into the investment chapter itself. And that's what's, you know, to preview kind of the last slide, what's extremely controversial about this case, right? So you can go first to investment. So, you know, where do you find this claim? And interestingly, NAFTA itself does not define intellectual property as an investment and does not define lost profits as an investment. And both of those are the core of what Lilly is claiming, that this court interpretation was a taking of their intellectual property, which confiscated a reasonable expectation of their profit. Neither of those terms actually are in NAFTA's investment chapter. They are in a much later chapter, so the 2012 Model and Bilateral Investment Treaty that USTR has published on the web and that it's seeking as a basis for the Trans-Pacific Partnership Agreements, do define both intellectual property in F and lost. Does this have a little pointer? Yeah. I can't really work. It's too high-tech. It's too high-tech for me. And in the first paragraph, towards the third line of the first paragraph, loss of an expectation of profit is defined as an investment. So neither of those occur in NAFTA, but looking forward, they are in subsequent agreements. So this is a very live claim to that extent, and a claim that you could find in many other forms. The fact that it's coming under NAFTA, I think, is relatively aggressive. So NAFTA itself and all other bilateral investment treaties actually have an intellectual property carve-out, because you can imagine exactly this issue. So the first part of this carve-out sentence says that the expropriation chapter doesn't apply to compulsory licenses. So this is not a grounds to challenge whatever royalty was deemed reasonable under the courts under a compulsory license. Nor is it applicable to the in relation intellectual property rights or their revocation or their limitation or their creation. So if you stop reading before the comma, it seems to fairly clearly carve out exactly this type of claim, that the adjustment of intellectual property rights by courts or legislature is not an expropriation under NAFTA until you get to the sentence after the comma. To the extent that such issuance, revocation, limitation, or creation is consistent with Chapter 17. Uh-oh. So what does that mean? So every revocation, limitation, exception to intellectual property law that isn't in compliance with Chapter 17 is an expropriation? That's the argument of the case, right? And you need to think through the implications of that, especially for all the intellectual property lawyers in this room that work in Stern Kessler's, generic litigation business, etc. That does provide the opportunity to have these claims shifting out of what I think was the intended structure of the chapter itself. So as Bourgeois mentioned, there's a patent chapter. The patent chapter patentability section is very short. It's the same as TRIPS. It doesn't define utility. NAFTA is missing a key flexibility language within TRIPS. So TRIPS has an Article 1 that NAFTA does not, and the last sentence of that is the basis for Bourgeois' statement that if the term is undefined, it's left for the country to decide how to implement that, right? She's quoting TRIPS, not NAFTA. So TRIPS says that members shall be free to determine the appropriate method of implementing the provisions of this agreement within their own legal system. And TRIPS scholars would say that creates any undefined term within TRIPS is what we call a flexibility, what Bourgeois referred to as a flexibility. So if you say you have to grant patents on the three-step test, but you don't have any definitions of what the three-step test is, except for industrial application permissively can be defined to include utility, then that leaves it to the sovereign discretion of the state to implement those terms as it sees fit. Different states can have different definitions of what that utility doctrine is. That's a TRIPS rule. So the question will be, does that TRIPS rule follow into NAFTA? It wasn't put in that agreement. So Eli Lilly's claims are quite broad, right? So this is from its original complaint, which has a whole bunch of arguments that are implicit in its second complaint, but more clearly stated. So their first interesting complaint or point, which just popped out of me when I started reading this, was that in NAFTA, every ambiguous term should be interpreted consistently with US and European law, is their argument. I don't know how Europe got there. Europe is not part of NAFTA. But they said, well, the way we got it in there is when you look at where NAFTA came from, it actually came from TRIPS, and it came from a specific proposal by TRIPS that was offered by the United States and Europe. So we should look at European and US law, not Canadian law, not international law, for the interpretation of ambiguous terms. I'll get back to that in a minute. And then they say, well, looking through US and European law, utility actually has a definite meaning within NAFTA. So in the second to the last part of this paragraph, or the last part of the paragraph, it means credible or plausible utility. That's what utility means in NAFTA. It has definite meaning, and its meaning is that the utility doctrine has to be implemented in a way that has a very low bar on utility. They're arguing you can't actually use utility as a place where you restrict the scope of patents in your own domestic law. And then the next big jump, and they say, and I know we're really talking about expropriation. When you read the complaint, it's very interesting that Chapter 11, which has to be the grounds for their complaint because this is ISDS, doesn't occur until the fourth to the last paragraph in the complaint. They actually, the first paragraph citing the law cites first TRIPS and then NAFTA, and they start with Article 1709. They don't start with ISDS, right? And you're a lawyer reading this, and you're like, this seems like bad pleading. You have to start with where your rights are, and your rights are in Chapter 11. Well, so the argument comes in paragraph 92, is their bootstrap. This action, they say, is illegal under Article 17, and anything that's illegal under Article 17 is an expropriation. So there it is. You notice the footnote is on the first sentence, not the second. They don't have any support for that argument. It's just stated. Now, that argument is incredibly broad. So that means you set out these two separate dispute mechanisms. You've got, 30 chapters in NAFTA. ISDS only applies to Chapter 11. Their argument, if taken and accepted, means, no, really, actually, ISDS applies to the entire chapter. Anything that's a violation of any chapter within the agreement that would impact a firm creates a right of action, they would say, for suing that party under ISDS directly. Okay, so some quick responses from an international lawyer. NAFTA doesn't say you should follow U.S. law in interpreting NAFTA. NAFTA actually says specifically in Chapter 11 that you follow international law, not U.S. law in interpreting its terms. And international law, as Bourdieu mentioned, has a set of rules on interpretation. Those rules on interpretation say that you shall not go to legislative history to interpret the agreement. There's another provision, Article 32, that says you can only go to legislative history if all of these create a continuously ambiguous text. So you're not supposed to, the first argument you make within your brief is the U.S. proposed this in another forum, and therefore you follow the U.S. law in interpreting it. Actually, you're supposed to look at the context of the agreement, including subsequent agreements between the same parties. So that's how you get Article 1 of TRIPS back in. And you also have an additional international agreement between the parties, which is the Doha Declaration on TRIPS and Public Health. And the Doha Declaration on TRIPS and Public Health begins to give some meaning to that term flexibility. So after a series of aggressive moves by the United States to attempt to challenge various patent laws in Brazil and South Africa, all of the TRIPS members came together and unanimously adopted an agreement reinterpreting TRIPS, which says that the terms should be interpreted to promote access to medicines for all, and that states remain with the power to implement any flexibility that moves towards that purpose. And this is, Bourdieu's fear about access to medicines. One of the things that states can do to promote access to more affordable medicines within their country is adopt more restrictive sets of patentability requirements. So if you think back to that, the original statement in both TRIPS and NAFTA, there's no requirement to have patents on new uses at all. So you have to have patents on inventions. Many laws around the world require that inventions be products or processes, not uses, and not new forms. So you don't have to have patents on new uses. And if you have patents on new uses, you are free to have very restrictive requirements for those patents. And the promise doctrine, I think, can be interpreted as such a restriction. And that presages what the implications are here more broadly, right? So there are 17 other free trade agreements with the United States which have intellectual property chapters, similar to NAFTA's. There are hundreds of bilateral investment treaties. Many of them define intellectual property as an investment. And these are not just with the United States, but there's a web of these agreements that bind countries all over the world. They're between developing countries, they're with the EU and developing countries, etc. The aggressiveness with which these agreements are now being used to challenge domestic legislation is making them much more controversial. The other, big one that's entering the public sphere these days is tobacco challenges. Challenges of tobacco regulations that limit the ability to have all of their advertising space on a cigarette package and require some or all of the package to be dedicated to a health warning, for instance. Those have been challenged in Uruguay and Australia. And these types of cases, as the bits bilateral investment treaties are subject to more and more aggressive arguments, which I think, going through the text, are non-frivolous. My own view is I don't think that they will prevail or should prevail, but they're non-frivolous under the way the chapters are constructed, so they can go forward. They continue to be an avenue that corporations can use to challenge what is seen as settled domestic policy, and that's leading to them becoming more and more controversial. And you see, and this is my last point, that the U.S. is starting to respond to some of this as well. So in a policy statement that was put out by USTR just 2 days ago, you see them in the last part of this statement trying to presage, trying to respond, at least rhetorically, to some of the concerns that people have around these agreements, and saying that they're going to try to fashion new safeguards within these new agreements for public health regulations. I think there's a lot of fear and trepidation around what those safeguards will ultimately look like, and of course they're not public. But the ones that are in the existing model bilateral treatment treaty, really, I would say, do nothing to stop this kind of a claim, and that's where some of the policy debates I think are going to be going forward in the future around this and other issues. So I'll